Hi, welcome all. Today we will discuss on new bill proposed on three major criminal laws of India.
Yes, Anish. Three major criminal laws of India: Indian Penal Code 1860, Criminal Procedure Code 1973, and Indian Evidence Act 1872 is renamed as Bharatiya Nyaya Sanhitha 2023, Bharatiya Nagarika Sanhitha 2023, and Bharatiya Sakshya Sanhitha 2023. So,
What is the change in IPC, CRPC and Evidence Act in new bill?
uh, if you look at the very outset, you will find a lot of changes because the number of codes are changed and the placing of the codes are changed, and it's a new act itself proposed to be brought into force. So when the actually there was a lot of opportunity for the government to make changes through amendment, but the government has preferred to change it through the act itself. So now the necessity of trying to change the replace the act itself by repealing the older acts. The reason for that was that the government wanted to like what the Amit Shah told in his parliamentary address, that the proposed bill is intending to replace the old colonial laws, what was written about 160 years back and it was prevailing in India. So all those are all actually outdated and they are all time consuming. That's what he meant. The British rule period was focusing on the British government, so and the authorities and the British rule. Such kind of words have to be changed. That's what was meant by the our honorable Home Minister. So the act itself, the older act is repealed and the new act is proposed to be replaced in that place. The name itself tells it's a Bharatiya Nyaya Sanhitha, Bharatiya Nagarika Suraksha Sanhitha, and Bharatiya Sakshya Sanhitha. That's what it is meant. But when the name itself will reveal that something like Bharatiya has been nationalization, nationalistic intention has been put up in that. But the fact is that what really made changes, that we have to only by discussion each and every major act, what kind of changes the proposed bill is willing to bring up is actually is in the course of discussion will come to know. Now at present, I would like to tell you, I would tell you certain facts that the major changes, when you talk about the sections, it is when we talk about the Indian Penal Code, everybody, the mindset is like this, that there are 511 sections like that, and we know very clearly that 302 is for murder and 420 for cheating and 376 for rape. It is in the minds and hearts and everybody, every Indian citizen may be knowing it, not only lawyers, because most of the movies also these kind of sections have been quoted, he has been incriminated as section 302, 376, like that and all. It's a talk of the every common man. But now the major change here in this IPC is that the name has changed into Bharatiya Nyaya Sanhitha 2023, which IPC had 511 sections. Now it has been reduced to 356 sections. This is 356 sections has got contains a stricter punishment for gang rape and rape of under 18, and also offenses against children, and crimes resulting in paralysis and brain death and such things. And for community, the community services also has been incorporated as punishment, and sedition has been removed or repealed, and the changes, the major change is that actually it is has no retrospective application. According to section 356 of the new Bharatiya Nyaya Sanhitha, and under section 350, 356, no retrospective in the sense actually if somebody has committed any offense previous to this enactment, then he will be tried in the old law only, not in the new law. Only it is prospective, or it will be applied. Like from the day of the assent of the president, once the bill has been coming to force and it is repealed, from the such date onwards, that whatever crime been committed or offense committed, it will be tried under the new law, like that. So that is what the change that is proposed in this. And like in CRPC also, there is a major sorry, in CRPC there are not much change. Like CRPC, the sections are not much change. That about 484 sections were there in CRPC. Now in this Bharatiya Nagarika Suraksha Sanhitha, here it is about 533 sections. That means some sections have been added. So 107 sections have been changed. 9 new sections have been introduced, and 9 sections have been repealed. So these are the changes in Nagarika Nyaya Sanhitha. And in Bharatiya Sakshya Sanhitha 2023, that means that the Evidence Act, earlier Evidence Act, there were originally there were 167 sections. Now it has been almost same. There is no much change I have found actually in Evidence Act, which is replaced as the Bharatiya Sakshya Sanhitha. In that about 170 sections are there. In that 23 sections are changed. 1 new section has been introduced, and 5 sections are removed. Major changes also include that regarding the filing of the charge sheet. The filing of the charge sheet was earlier, it was in the old act, it was about 60 days. Now it is proposed to be increased to 30 days. Then here more emphasis is given on digital recording of evidence. Like while filing the charge sheet also, it is being made like mandatory for video recording, and also even cross-examination and all such court proceedings can be carried out through video conferencing and such things. And regarding the even when somebody has to actually get his vehicle released, earlier it was a cumbersome process, but now he has to give an indemnity part, not to not to change the color or not to alienate that particular property, like that, and also many undertakings are to be taken. But now in the proposed bill, the video, a video record will be stored as an evidence, and no need to actually retain the vehicle in the custody of either by the police or in any other custody, to ascertain certain things like that. During the matter of trial, once it is been filed in the charge sheet, then it is sufficient with the video footage. It is sufficient for the vehicle to be released. It is not made this. This is a major shift in the earlier procedure and in the new procedure what is proposed. And another major shift in the changes in the criminal procedure code is that, earlier, if you had to file a criminal complaint against any government officer, it was mandatory to obtain permission from the higher authorities. And sometimes one could not get any permission for a long period of time, and one would lose interest in that particular case. But here now there is a great proposal that if the higher authorities will not respond for 120 days, then automatically such a complaint will be taken into cognizance. It is not necessary that he need to give the permission. Either he has to reject to give the permission, or he has to give the permission. The higher authority has to give the permission or can reject to give the permission within 120 days. Otherwise, it is deemed to be taken as when the consent has been given by the higher authorities. These are all the major changes. But also one more thing is that filing of the charge as well as judicial custody, police custody also is expected to increase from 15 days to 90 days. such major changes have been done in this particular criminal procedure code. In IPC, as I told you, that IPC, as I told you, there are lot of changes. Earlier, the rape section was 376. Now it will be 64. Earlier, murder was 302 IPC, and now it is 101 VNS Bharatiya Nyaya Sanhitha in that. And also there is a new IPC section introduced, is triple one, that is 111 for the terrorist act, and so many other changes have been done. Anish, one major striking change in the new CRPC, that is Nagarika Suraksha Sanhitha, is that zero FIR. Zero FIR, in the sense, it was a long pending demand from every citizen of India that actually regarding the jurisdictional police, like for example, if any offense was committed in some area, and usually when the person used to go to the police station, police people used to refuse telling about the jurisdiction for registering the FIR, quoting that actually whether it is falling in a rural area or in a town area or in some other portion of the this one. That's the reason people used to suffer a lot. Now actually, because of the zero FIR concept which has been introduced in the CRPC, it will be a great help for everybody, so that actually wherever you the nearby police station it's available, you can register a complaint. So this will be a major change, game changer as far as the new law is concerned.
What are the plus points and negative points in the new bill?
Yes, Anish. Plus point is, as I told you, when any government servant been actually incriminated in any case, in such case, deemed permission is sought, and digital recording of evidence, and digital mahazars, and even that documents to be retained in the court by video recordings. These are all the plus points. And moreover, actually, there are some proposal has been made in that, for judgment. Once you hear the judgment, hear the argument, then the judgment has to be made within 30 days. This is the proposal. Then even for us, if any case is a petty case, if it is below 3 years, punishment is there. For that, within 6 months summary proceedings, it has to be completed, that process of trial. These are all the plus points where actually judiciary will have a speed up, and so many mindset will change. And as I told you, that the government was, the officers were going scot free, because higher authorities never used to give the permission. The deemed permission will matter a lot. And moreover, actually, the vehicles used to rust and get damaged in the custody of the police, or in whatever, when some vehicle is seized, it used to lie for years together, and you can take into account, under the forest laws and all, they will not find the chassis at all. In such case, what happens is, it used to the vehicle used to get destroyed inside the premises of the on the judicial permission only, it is to decay there itself. But now it is not so. Those are all the plus points. When you talk about the negative points, there is a lot to speak about in the negative points, because one should take into account that when our Home Minister told, when he introduced the bill, he told actually it's a major shift from the colonial mentality. That is not so. When you go through the exact page to page, what is the major shift like that, you will not find any major shift in the provisions of the law. Why? Because this was actually drafted, this Indian Penal Code or Indian the Criminal Procedure Code were drafted in the way back in 1860 by Lord Macaulay. But such act have been amended several times, and it had no, there's no such necessity to replace the law itself, because see, if you think railway system is introduced in India by the Britishers only, but are there, whether the Indian government preferred to replace the railway line itself? It is not so. Like, it was not necessary to replace the total system, like the act itself, but the government has proposed to do that. And while going into the contents of that act, I find a very interesting part is that it is nothing but a cut, copy, paste of what was there earlier. IPC, CRPC, and Evidence Act all are cut, copy, paste, because if you go through the errors, see, there are a lot of errors also have creeped in the new law. How the errors creeped in? Because you can very easily find out the fact that you take, for example, section 376 was the old law, and section 64 is the punishment for the rape in the new law. So now let me read out the section 376 of the old law, punishment for rape. Whoever, except in cases provided for the subsection 2, commits rape shall be punished with rigorous imprisonment of either description for a term which shall not be less than 10 years, but which may extend to imprisonment for life, and shall also be liable to fine. So here, when you find out that either description, here simple imprisonment or rigorous imprisonment, that should have been mentioned like that. It is simply imprisonment is missing. So when I'll just read out the punishment for rape in the section 64 of the new law, it is mentioned like that, like this: whoever, except in the cases provided for in subsection 2, commits rape shall be punished with rigorous imprisonment of either description for a term which shall not be less than 10 years, but may extend to imprisonment for life, and shall also be liable to fine. This is what actually cut, copy, paste, and the mistake what was committed in the earlier law has been reproduced in the new law. That means we can very easily find out that so it is not a new law at all. It has been actually simply replaced with making the sections up and down. So it is been made to feel that new law has been introduced. We are all in the great expectation that new laws will make a major changes in the shift in the provisions and applications and all such things. Such things have not happened. Here they have just cut, copy and pasted in this, and while doing so, when we can recall back to the school days also, there was a popular joke. While copying the answer paper of the neighboring student, don't copy his name also like that. That's what actually we used to popularly joke in the school days. But the same thing has happened in a major code. It's the Indian Penal Code has been replaced by Bharatiya Nyaya Sanhitha, and they tell, the bill tells that this is a new, totally new provision been introduced. A new bill has been introduced for a new act, but it is not so. It is the error. When they have copied the error, very easily we can make out that the error is copied, and the entire set of the what earlier law is also copied. And coming back to another major defect, what I find is actually section repealing of the total repealing of the section 377. So in the judgment, landmark judgment for unnatural offences, it was not so. That was, as I remember, Navjot Singh Johar versus Union of India. In that judgment, section 377 of the Indian Penal Code was struck down to the extent that it is criminalized same-sex relations between the consenting adults. Same-sex relationship with the same between the consenting adults. So such that part was only struck down, that consenting adults. So here the total law, that section 377 itself is not finding any place in the new law. So no gender neutral law has been brought in there, where actually so because of this new law, a man can't be stalked, a man cannot be sexually harassed, and now a man can't even get any specific remedy when he is raped by another man. So this is the very interesting part of it. They should not have struck down the section 377 completely. It should have been there, found place where actually when there was actually any sex without any consent by man to man also, that should have been retained. But they have done a major fault in this, and it's very clear that the lawmakers have not applied their minds, have not their applied their mind in like striking down this particular section 377 of the old IPC. So now these are the major things which will flash to one when we go through these laws. I would like to throw light upon one more big error what has been committed by the drafting committee. I was talking about cut, copying, pasting of the old law into the new law. While they had, when drafting the new bill, the persons who have drafted, they have committed a major error in the grammatically also. So I'm just not just actually pinpointing out the mistakes, but when it is a law, new law has been framed, our own law, why grammatical mistakes? Of offences against women and children. Women means WOMAN and children. It should have been WOMEN and children. Either it should have been women and child or women and children. So they have totally completely failed even to apply their minds while drafting a new provision also. And in the same provision, chapter 5, major error you can make out is section 81, where marrying again during the lifetime of husband or wife. See, the major headline is offences against women and children, and how come the section 81 will come? Marrying again during lifetime of husband or wife. Whoever having husband or wife, leaving marries in any case with such marriage is void. So this is what is mentioned, shall be punished. So having a husband or wife, how can a wife can have another wife? And how can a child have another wife? So these are all the major errors what you can find out in the drafting committee has done in the new bill. They have cut, copy, pasted it. They have also committed a lot of grammatical errors where actually which may lead to confusion, and it also shows that there is no depth in the law, new law itself. So these are all the errors what have been committed. And major thing I would like to bring to the knowledge of the viewers here, that Sedition Law has been scrapped, what was told by the Home Minister, section 124A. This is a very draconian law. Gandhiji once called it is a principle of all political law, prince of all political laws. It was told by the Gandhiji himself, and Gandhiji was arrested under this law because whoever causing disaffection against the government were tried under Sedition Law, and they were put into prison. Maximum punishment was for 3 years. And very proudly our Home Minister told that 124A has been totally scrapped. But it is not so. Dear viewers, please kindly go through section 150 of the new Bharatiya Nyaya Sanhitha, where actually you can find the section where actually any offence against the secession or separatism against the state, or spreading news, wrong news about the state, affecting the sovereignty of India, sovereignty of the country. In such case also, actually the same kind of law has been put forward there, which is just 150 section has replaced this 124A. So and also this 153B has been replaced by section 195. So these are all very discouraging like when we are come with the open mind, when we are thinking sedition has been removed, and also section 153B has been removed, that is not so. It has been actually replaced with section 150 and 195. So these the lawmakers or the proposed bill have attempted to just suppress certain things and bring it in a newer forms. It is not welcome to everybody. So serious discussion is required before the introduction of this bill, before the Rajya Sabha and before getting the assent of the president. I don't think much of the consent has been taken. When these bills were put forward, the lot of errors, cut, copying, pasting, and introducing of the new provisions also, lot of errors been committed. And one more drawback what I find is that now the sections are changed. Now the sections are changed. So a new law student or a new law, not a new law, old law practitioner himself will find it very difficult to actually get the citations, when he has to have the knowledge of both the laws now. Both the laws in the sense old law as well as the new law. And the new law section has to be compared with the old law section, only then he can get the citations. So it is very difficult, cumbersome, and it will be very time consuming for the practicing advocates as well as the law students, because unnecessary it's an exercise of unnecessary for no reason, because most of the things are cut, copied and pasted with the introduction of new smaller laws, and just replacing the sections there, here and there, has unnecessarily created cumbersome procedure for the people who are actually practicing law. So I think actually certain sections, not just certain sections, that amendment of the earlier law and the inclusion of certain provisions in that amendment should have been more appropriate for saving the time. And also in the law, it is told that either the judgment has to be given in a specified period like that. That one has to think. Actually, what is a mandatory provision, like a mandatory aspect in judiciary is that for every 10 lakh people, there should be 50 judges. But in our country, for every 10 lakh people, there are only 19 judges. Then the time frame has been fixed. Once the trial starts, in this time you have to complete the, do the judgment like that. And after the argument, within 30 days, you have to do the judgment like that. Such kind of proposals have been put in forward in this bill. I think it is not humanly impossible, certain things, because even judges are human beings and they have got limited times. They need to have they have their own vacations, and they cannot simply be pressurized to bring in the delivery of the justice within a time frame. So these are the aspects are not considered in the new law. The new bill proposes to bring digitalization into a far greater extent for recording evidence, for storing evidence, and so many such things. But you can see the state of the courts. Even for getting a photostat copy, we have to struggle. A copy application we make, and the photostat photo copying machine has undergone repair, and we need for arguments we won't get copies. Such is the state. Such attention has not been given. But just building big buildings is not the thing. When you are trying to make digitalization, then in such case actually you have to make a lot of improvement. Just introducing the provisions in the bill will not solve the problems. So in that case actually I think the lawmakers have not applied their minds properly, and simply they have introduced this trying to introduce this bill, which will definitely come into enacted, I know, because actually majority is there for the central government. It may be enacted, but they have not weighed the pros and cons of what really is going to happen, whether it's practically how much difficulty one has to face, the law practitioners have to face once these bills are introduced and becomes the enactment.
What is your personal opinion
Regarding the new bill? Yes, see, my personal opinion is that there are new things introduced in the new bill, mob lynching has been brought into law. Then organized crime has been brought into law. Terrorism has been brought into law. digitalization of the procedures are brought into law. These are all the welcome aspects. When you talk about that 153B, replaced with section 195 and 124A replaced with 150, these are not welcome. Because see, and again, more powers have been found to be given to the police. Where the police had the opportunity to, for the police investigation, they could have sought for 15 days. Now, in this new bill, proposed bill, there is an opportunity for the police to even to get for 90 days custody. These are all not welcome because it will endanger the personal sovereignty, personal capacity of any individual, personal right of any individual. So now what I would like to tell you is only so much that the proposed new bill is not that really happy for us, because this handcuffing and all, the yesteryears only it was in the Basu versus state of West Bengal also, handcuffing was not allowed. But here in this case, such provisions have been introduced, and here actually for filing of the charge sheet also, it was 60 days, increased to 90 days, and an extension of another 90 days are all not welcome. So I feel instead of introducing these kind of new bills, it was just sufficient just to make amendments. Why not? When you have made so many amendments, you could have done the amendments, and less of cumbersome procedures could have been avoided. No such thing has been done. So I feel actually all over India, the advocates and the Bar Council also have to give suggestions regarding this, so that I personally feel that instead of introducing the new bills, it would have been sufficient to actually amend the aspects, so that it would have been more helpful for the law students as well as the law practitioners. So by and large, I feel it's only a cut, copy, paste bill, and there is no nationalistic, there is no shift away from what has been told by the Home Minister, that from the colonial thing we are just moving on to the people friendly law. It is not so. Had it been a people friendly law, then it should have been drafted afresh, new, according to the times. It has not been done. It has been cut, copy, pasted, and the drafters have also committed errors in that drafting. So I don't think it has been actually a game changer. It is just another part of a new game, being in the old wine in the new bottle. So I don't feel it's a good move by the government just for the purpose of the forthcoming election. Such bill has been put forward, and many such Digitalization Act and so many other things have been introduced only recently. This is not welcome. The thinkers, lawmakers, as well as the concerned advocate organizations have to express their opinion and to make and propose to make changes in this bill, or else to just I personally feel that amendment would have been sufficient in the place of these bills. Thank you. This topic will be discussed once again in the local languages, because it is, I feel, it is my bounden duty. After going through the PDF of the new bill, I feel each and every advocate, each and every citizen, everybody, because this law is being replaced after 160 years, I think lot of discussion is required regarding this in the local languages. Every nook and corner it has to reach. So I feel like speaking on the same subject in the local languages in the coming days. Thank you.
Anish, one major striking change in the new CRPC, that is Nagarika Suraksha Sanhitha, is that zero FIR. Zero FIR in the sense, it was a long pending demand from every citizen of India that actually regarding the jurisdictional police, like for example, if any offense was committed in some area, and usually when the person used to go to the police station, police people used to refuse telling about the jurisdiction for registering the FIR, quoting that actually whether it is falling in a rural area or in a town area or in some other portion of the this one. That's the reason people used to suffer a lot. Now actually, because of the zero FIR concept which has been introduced in the CRPC, it will be a great help for everybody, so that actually wherever you the nearby police station it's available, you can register a complaint. So this will be a major change, game changer as far as the new law is concerned.